So Practice Directive 59 regulates how and when a matter is enrolled for hearing. A legal practitioner has the obligation to check his file in terms of the PDs and then file an Annexion 9. The Annexion 9 is indicating whether the matter is ready to be heard, whether the judge should read it, whether it was on the roll previously, and if so, what happened. It is then also signed by the legal practitioner, and at the bottom of the page he or she need to indicate when they were admitted. Now, the practice directives is a very powerful tool on the one hand to ensure the regulation of these matters on the roll, and that there is a it's properly done. The proceedings must be in a form of orderly conduct to be in compliance with the court rules. Now, the PD 59 deals with matters in paper files as well as in electronic form. To enroll a matter that hasn't been enrolled previously, the legal practitioner must do that at no later than 12:30 on the 8th day prior to the date of hearing. Again, that is court days that is counted. If it is after the 8 days, then it is after the DS has expired. It will still appear on the roll, but the registrar will also indicate on the court roll that those matters were enrolled after the expiry of the DS. Once the file is prepared by the research assistants and they note that it was enrolled late, they will bring it to the attention of the judge, who will then, in all probability, remove the matter from the roll. The practice directives is quite firm on it that it must be the notice of set down. There must be the Annexion 9, and then there must also be a draft order that is filed. So in a divorce action, the litigants must also ensure that the marriage certificate is available, that the particulars of claim is on the file, that the return of service is on the file, and that the certified copy of the marriage certificate is on the file. If there is a settlement agreement, that also need to be placed on the file. Now that is specifically with a paper file. The Annexion 9 in paper files, every time that the matter is enrolled on the undefended matrimonial roll, the Annexion 9 need to be completed. So the more recent one would be placed on top in the file, and it is a Romeo form that lists a few questions that need to be answered by the legal practitioner. All the older Annexion 9s must be filed right at the back of the file in date sequence. This is obviously not possible in e-justice, so the Annexion 9 will just be uploaded. The return of service must be uploaded before the parties can move for a final order, and by that time the certified copy of the marriage certificate have to be on the e-justice already, and then there must also be a draft order. Now, I'm just going to briefly address the issue of settlement agreement. In many of these undefended matters, there's a settlement agreement that can be made in order of court. So in seeking a final order of divorce from the court, and in the event of an order incorporating a settlement agreement between the parties, the legal practitioner must ensure that when checking the file in the undefended matrimonial court, that the original settlement agreement is available. On the paper file, it needs to be available, but the original must be in court when you deal with an electronic file. It must then also in the draft order specify whether the settlement agreement as a whole should be incorporated in the final order for divorce, or whatever issues, whether it's the issues of the division of the matrimonial property, custody and control of the minor children, maintenance for the children or maintenance for the spouse, and other ancillary matters. The settlement agreement will not be handed in during a matter that is filed on e-justice, because what do you do with it? If you have a paper file, the presiding judge will receive it into evidence, mark it as an exhibit, it will remain on the file. But you cannot do that with e-justice. So what happens is that the settlement agreement will be handed to court for purposes of comparison with the one that is uploaded on the e-justice system, and it is then handed back to the council. Now, what is important in respect of the PDs is that PD 59.6 is very specific. If that Annexure 9 has not been completed and is not on the file, or it has not been uploaded, the presiding judge may not hear the matter, and the matter will be struck from the roll with a possible order as to cost. So if the legal practitioner has not uploaded a draft order, he runs the risk of the matter being struck. And equally, if the time periods as set out in the PDs has not been complied with, the matter will equally be struck. It's always not postponed, but it's always in the discretion of the court to condone the non-compliance with the practice directives in this regard. But quite honestly, at this point, the judges dealing with this it's quite firm. If it's not there, the matter is struck, because PD 59.6 says that if the Annexure 9 is not filed, the judge cannot hear the matter, and the matter must be struck. It's not the matter can be struck, the matter must be struck. So it depends on your interpretation of that. But the current position is that the matter will be struck. Right. In respect of the settlement agreement, the settlement agreement must comply with the Stamp Duty Act. The Annexure 9 is an annexure to the court rules, so you can go through that as well just to see what exactly the questions is. But as Charlotte said, the requirement is that you check your file to see that all your documents are indeed there and that it is ready to be heard. And if it does not appear, you clearly haven't checked your file, then you will not be heard. Yeah, in respect of settlement agreements, it looks like one of my slides was a bit out of sync. The settlement agreement must be initialed on each page and fully signed by both the parties on the last page or the second to last page. Sometimes the one signs on the last and the other one on the second to last with the witness's signature as well. And as already indicated, the original settlement agreement must be in court on the date of hearing of the matter. And it will then either be received into evidence as an exhibit or in case of an electronic record in terms of Rule 135.10 that deals with safekeeping of records. It will be handed back to the council. I think if you look at Rule 135 sub 10, it provides that the council need to retain that document for a period of at least 5 years. And as in the office is keeping it safe. Okay, so once the matter is now duly enrolled on the undefended matrimonial roll has been checked. It's ready to be heard. It is in compliance with the rules and the practice directives. The presiding judge will then proceed to hear the matter. The plaintiff's legal practitioner would call the plaintiff to come and testify. The witness would be sworn in. If the witness is making use of an interpreter that is not an official interpreter, the interpreter needs to be sworn in as well. Obviously, the witness has a right to testify in his or her language of choice, and therefore the need for an interpreter. Unlike in the lower courts, in the High Court you can bring your interpreter along. The interpreter is then sworn in as a casual interpreter for that specific matter. The permanent interpreters are not always available, and so in many instances a casual interpreter is required to deal with the matter. Hereafter, with leave of the court, the legal practitioner will then proceed to lead the plaintiff. During the oral evidence of the witness, he or she will confirm the identity of the defendant or the spouse, will confirm that the parties regard Namibia as their permanent home and therefore they fall within the jurisdiction of the High Court of Namibia. The date of the marriage and the place of the marriage is important in respect of where the marriage was concluded, and that is with reference again to the Native Administration Proclamation 15 of 28, where there is reference to the police zone, and where the position is by default that the parties are married out of community property. In many instances, this would not be correctly reflected on the marriage certificate. Then the marital regime, or the married in community, out of community property, accrual system, whatever the case may be, whether there were children born from the marriage, and if so, what are their names, the dates of birth, and where the children currently reside, and then also the grounds of divorce, which is normally set out in detail in the particulars of claim. This is now where the list would be: he or she invite constant argument, squanders the money, the whole list. Unfortunately, I did not time to have to make copies of a few particulars of claim for you, but I can always make that available that would be helpful in getting an idea what can be set out in the particulars of claim. And then obviously the prayers, what is prayed for. The prayers would normally deal with the proprietary rights. It would deal with custody and control. It would deal with access. In a case of married in community of property, it will deal with the division of the joint estate. But the prayers is fully set out in the particulars of claim. During the evidence of the plaintiff, he or she will then also be called upon to identify the marriage certificate. In a paper file, by that point, there would be a certified copy of the marriage certificate filed. In court, the marriage certificate would be handed in by means of the plaintiff, who will identify the original marriage certificate. In many instances, the plaintiff would not be in possession of the original, but have a duplicate original. If that is indeed the case, the plaintiff should be invited to explain why he or she is not in possession of the original marriage certificate. So the marriage certificate will then be marked as an exhibit. I make a point of checking that the marriage certificate on the file corresponds with the one in hand. and that the serial numbers also correspond. In e-justice, you will have to, while in court, open that specific case, open the file containing the marriage certificate and compare. Must be look very carefully at the marriage certificate. Sometimes, especially if it was a marriage officer that concluded the marriage, there would not be a say a marriage officer number or a date stamp. Not all the marriage certificates are fully completed, so you need to be quite vigilant and check that it is complete. If it is, say, a marriage that was concluded at a marriage at the magistrate's offices, there need to be a date stamp of the specific magistrate's office where the marriage was concluded. So carefully go through it, and that is where preparation comes in, because you will note that in advance already. Can be corrected. In that case, the matter can be postponed to enable the parties to obtain the correct one. It can also happen that the RCR is granted, but that the final order will not be granted unless the correct document is before court. Look, I know about these issues. I haven't had to deal with a matter like that, so I do not want to go out on a limb and say, yes, it's null and void, or no, it's not. But I do know that this happens. And it would appear quite regularly, actually. And in many instances, when it really comes to bear, is when there's a problem with in respect of the divorce and the proprietary rights that go along with it, or it is incorrectly reflected on the marriage certificate. The problem is if it wasn't registered with Home Affairs, that is where the issue comes in. But unfortunately, I can't give you the answer now. I have to come back to you on that. In all probability, but you would probably not deal with that in an undefended matter. That is when the matter is defended, you will have to deal with it. That wouldn't be on the undefended matrimonial roll. That would be a defended matter. And then you have to, as Ms. Nelly just indicated, you will have to deal with this on an interlocutory basis in all probability. But it will not be on the undefended matrimonial roll. Okay, once the court has heard the counsel for the plaintiff and the evidence adduced by the plaintiff, the court will then, if satisfied, issue a restitution of conjugal rights order. This RCR order will then, if there's a settlement agreement, it must incorporate the settlement agreement. It will then also, you will see in the order there's two dates. The first one is the RCR order, that is the date which call on the defendant to restore conjugal rights to the plaintiff within a specific period of time. And the second date is then the return date of the restitution of conjugal right order, on which date the defendant can show cause why the subsistence of the marriage between the parties should not be dissolved. Now, now the parties reach a settlement, and then that settlement is incorporated during the restitution of conjugal rights proceedings. But the defendant has the opportunity to show cause why it should not be made an order of court. So it's not at the end. It's right in the beginning, actually. Not all of these divorces are finalized on the basis of a settlement agreement between the parties. So there can be a whole host of orders that the court make. So some of them are very, very simple, like just the bonds of marriage subsisting between the parties, why that should not be dissolved and why the joint estate should not be divided. But then obviously when there's children involved, it becomes more and more complicated if it is not encompassed in a settlement agreement. So what you have before you now is just an example of a restitution of conjugal right order, which would read that after hearing the plaintiff of the counsel for the plaintiff and the plaintiff, that the court then order judgment for the plaintiff in the form of order of restitution of conjugal rights, and order the defendant to return or receive the plaintiff on before a specific date, and then failing to show cause why, if any, then on the date that follows thereafter is again an undefended matrimonial date. Now, this first date, the next example is just where a settlement agreement was handed into court, and you will see that the order is then substantially shorter, where it just indicates and why the settlement agreement should not be made an order of court. But the first date that is it's calculated, it must be served on the respondent on the defendant personally, not less than 14 days before the restitution date. The dates are and how it's calculated is set out in the rules. So it must be served 14 days before the first restitution date, and then it's 6 weeks thereafter that your return date will be. So if the matter is on the roll, or the restitution date is the 27th of November 2017, the service need to be effected at least by the 6th of November, 14 days prior to that date, otherwise it will be short. It is counted in court days, obviously then excluding weekends, and excluding the first, including the last date. The second date in your order is then the return date of the rule nisi, and that is then a motion court date. That is a date that is published in advance for all for unopposed divorce matters in terms of Rule 88 sub 2. So your RGR date is not a undefended matrimonial date, but your rule nisi date is. The calculation of the dates can be quite confusing. The registrars or the research assistants also you need not worry too much about it. Obviously you need to know how to calculate it, but it will be indicated on your court roll as well. It will be calculated in advance. The date before which the defendant need to return to the plaintiff. That is to give him the opportunity to change his mind, to go back and reconcile and restore conjugal rights. If that hasn't been done, yeah, it can be. It's not a motion court date.
Not coming to court.
No, they will only return to court if you haven't reconciled. Then on the rule return date of the rule nisi, then you need to be in court. Then the plaintiff will come back. The defendant then have the opportunity to come and say, I wish to show cause why this must not be made a final order. But if the matter is settled, the defendant would not return. But in matters where there is not a settlement agreement, there is a possibility that the defendant can come back and say, you know, I don't have a problem with divorce, but I have a problem with some of the ancillary matters, and that is addressed. So the fact that these rule nisi does not mean that the defendant is precluded from being at court on the return date to come and show cause. It will be judge allocated to deal with the matter. Yeah, as I already said, the defendant is not precluded, and there is a very nice case from the Supreme Court dealing with exactly this. That's the case of Vayakeni versus Vayakeni, where the Honourable Chief Justice wrote the judgment in this regard, to say that on the return date, the defendant can come and address certain ancillary issues. He or she is not precluded. But can also happen that that for some or other reason that the RCR order could not be served in time. Then the council will come approach court again and then pray for new dates. Plaintiff need not be there, but the new dates will then be again for the RCR as well as for the rule nisi on that. This is an example of such an order. Just the new dates are set, that the restitution of conjugal right to be effected before a certain date, and then the return date of the rule nisi is extended. You must remember this was done on an ex parte, so there's a rule nisi. A rule nisi need to be extended every time, otherwise it lapses or it's discharged. It need to be extended if the matter is postponed. That is if the RCR order could not be served. If the RCR order is served, but for some reason on the return date, a final order cannot be made, then there will be an application that the matter be postponed and that the rule be extended. Because on the return date, the plaintiff's counsel need to have filed a affidavit of non-return and the return of service of the rule nisi to prove that it was served on the defendant. Now, the affidavit of non-return will state that in terms of the court order, the defendant had a certain period of time to restore conjugal rights, and that the defendant failed to restore conjugal rights on or before that date, or failed to receive the plaintiff back. This must be done in front of a commissioner of oaths. It is an affidavit by the plaintiff under oath, signed and then commissioned. It can be commissioned by a legal practitioner or an ex officio commissioner of oaths, but if it is done by an ex officio commissioner of oaths, the stamp need to be there. And it obviously need to comply with the specific regulations dealing with commissioners of oath. So, say for instance, the affidavit of non-return isn't there. The council will request that the matter be postponed until the next motion court date, and in that instance the rule nisi will just be extended until that date. If they, however, do not come back to court for some reason, on the return date, the rule nisi would be discharged if there is no appearance by the plaintiff. So in order to reinstate the rule nisi, because once the rule nisi is discharged, the plaintiff can take no further steps, nothing. The rule need to be reinstated, and that will normally be on application. And the court, if so satisfied that good cause was shown as to why it should be done, then will extend the can either extend the rule or reinstate the rule on application. So grant new dates or extend, but it's on application. So you can't go any further. Once your rule nisi has been discharged, you're stuck. You need to go back to court and show good cause why it should be reinstated. And sometimes they would remove it from the roll because it could not affect service or whatever the case may be. There might be a multitude of reasons why there was no appearance on the final date. And that is when Rule 88, sub 7 need to be followed. You must remember that this is just, should the defendant want to restore and go back, he have that choice. That is giving him a second bite to the cherry, basically. He's not obliged to do so. Because if he does not return to the plaintiff and restore conjugal rights, a final order will be granted.
So they're not considered to be in court?
No, they're not. And that is why the order invite them that they need to restore conjugal rights before a certain date, and they can show cause. But if they elect not to do that and make no appearance on the return date, a final order of divorce will be granted. So it must not be regarded in the same as another court order. So on the return date, once the RCR order has been served within the period of time as set in the court order, which is service on the defendant personally, the counsel for the plaintiff can move for the final order of divorce, provided that, as I already said, the affidavit of non-return is filed, wherein the plaintiff then indicate under oath that in spite of the RCR order being served on the defendant, that he or she did not restore conjugal rights, and in case of substituted service, then proof or edictal citation proof of same being filed as well. With your substituted service, it will be proof by means of a tear sheet, or with edictal citation will be by means of apostille. Depends on the country where it is filed or served. Well, obviously, the defendant will have to be at court on the date of the return date, and present that to court as well. Then that matter would at the end of the day probably turn into a defendant matter. But I must say, fortunately, I haven't had that experience yet. We have had where the defendant would come to court and then say, you know, I don't want this to be finalized. Then the defendant will have to testify under oath and show cause why the court should not consider making a final order. And that would then be appropriate in that circumstances for the defendant to come to court and say, well, I've complied and this is the position. The return of service, that is of proof of the service of the restitution order. That is prima facie of the evidence in the matter stated therein. So once the court receives the return of service, indicating that the RCR order was served on the defendant, the court will accept that as prima facie evidence in terms of Section 32(2) of the High Court Act. So if the defendant then does not appear to show at a court on the return date to show cause why the divorce should not be made final, the court will then proceed to finalize the matter and remove the matter from the roll. However, on the return date as well, the legal practitioner must make sure that he or she complies with PD 59 and to then file the Annexion 9 and also then a final order. So if there is not an agreement about the ancillary issues, so if the defendant then come back to court on the return date, then I would really invite you to read the case of Vayakene versus Vayakene. It's an extremely interesting case where the issue of ancillary matters was discussed because the parties can be divorced and then there are still ancillary issues remaining that can be dealt with at a later stage. So nothing prevents the court from hearing the ancillary matters at a later stage. Many of the parties doesn't have an issue with the divorce. They want to be divorced, but they can't agree on the ancillary issues, and therefore, in order to move matters forward, the divorce is finalized, but the ancillary is then dealt with afterwards. Because you don't go into the merits of the ancillary matters when you finalize the divorce matter. So there's no reason why not. In many instances, the matter will come back to you, so I can't see why not. Just on the issue of service, like in South Africa, the proof of service by the Deputy Sheriff in South Africa is sufficient proof of any documentation. If it's done by any other person apart from the deputy sheriff, a certificate of the person who served the process in South Africa must be duly authenticated. However, in your foreign countries, the rules specifically provide which countries it can be authenticated by means of a certificate, and then which need to have an apostille. So I can just refer you to the rules in that. You must also remember if there's any documents that's in a language other than English, it need to be translated by a sworn translator, and that is also set out in the rules. Your translation of your documents is in terms of Rule 126. It will sometimes be in respect of agreements between the parties that are not English speaking, and then authentication of documents executed outside Namibia for use within Namibia is dealt with in terms of Rule 128 of the Rules of Court. Unfortunately, due to time, I did not have really time to deal with the issues of forfeiture of property. I will, however, make a list available of cases that are important in this regard to read, like the judgment of Acting Judge Heathcote in the matter of Maria Sea Carlos and Alphonsine Lucien and Alois Lucien. This is a judgment that was already granted in 2011 that deals with also the issue of the guilty party and then the forfeiture of proprietary rights. This is a very important case to read in that regard. In many instances, there would be an application that the rights to property be forfeited in favor of the plaintiff. And property in general is a very sensitive issue, and it can give rise to protracted litigation if the parties cannot agree on it. Also be aware that settlement agreements, go carefully through the settlement agreements before it's made an order of court. Make sure that especially in respect of the issue of children is dealt with properly. I do not want to go into joint custody at this stage. There's quite a few cases on why the court should not consider joint custody and the problems surrounding that, but in contrary, there's also quite a few judgments that says that the time have changed and the best interest of the child is paramount. So when a settlement agreement is serving before you relating to the interest of children specifically, you need to understand and remember that the High Court is the upper guardian of all minors, and that ultimately the best interest of the child is considered. Even if parties has reached a settlement agreement, it does not mean that the matter is res judicata, because custody and access is always variable. Also in respect of maintenance of minors. There are, however, cases that that I could see that deals with res judicata when it's a settlement agreement, that where the findings were that when it deals with property and with the spousal maintenance, that is res judicata and cannot necessarily be revisited, but not the issue of custody, access, and maintenance to children. So, sometimes the parties does not really think a settlement agreement through, and they just present it, they present it to court basically to rubber stamp, but just go through it and satisfy yourself that the interest, or that it is in compliance with the rules and it deals with specific issues. You will see that is dealt with the issues that need to be considered is also dealt with in the rules. Your matrimonial matters is from Rule 87 through to Rule 90. So, yeah, that basically concludes my presentation. I would make a list of cases available to you that you can read through, consider. Unfortunately, I did not have the time to include it in the slideshow, but I will make it available to Mrs. Pluter, and then you can go through it. This is an ever-changing, there's ever-changing issues in this, and there are very, very enlightening judgments currently, as we speak, that came from the High Court of Namibia in respect of matrimonial matters. So do yourself a favor and read a few of the judgments. There's a very nice judgment of Judge Masuku where he did a comparison of a lot of different countries in this regard. But all this, I will give you the citation of the cases, and then you can read it at your own time. I think I can refer you to a few cases where it would say that is contra bonis mores, and you can't do that. Even if parties in advance decide we want to get married, and you're going to say you were in an adulterous relationship, etc., that is contra bonis mores. Unfortunately, I don't have the cases here, but I had an argument in a similar vein not too long ago, so I can refer you to a few cases in that regard. No, then if the marriage is voidable, you have to institute action. It's a claim for nullity of marriage, and you still have to institute action and seek your relief in the High Court, ordering or making a declaration that the purported marriage has been null and void ab initio. I have not dealt with something like that, but you don't go through divorce proceedings. These are specific claims for decree for the nullity of marriage that you then file. Statutory. It's in terms of statutory provisions in the Divorce Act. It's Act 17 of 79, but it's statutory. Yeah. That can be the consequences of it, yeah. That is why, the High Court on so many occasions said that our divorce law is so archaic and outdated and hasn't been keeping up with the times. So it is in dire need of being reviewed. Well, as far as I know, there is legislation that is on the way. Yeah, there is reform on that. I think I saw the draft in March or April of this year already. So we are moving in the right direction. But I think we are literally moving towards the light in this regard. There is draft legislation. So we need to keep up with the times. Rule 25 you need to read together with Rule 18. Look, the case will be case managed as like any other case. However, the case will in all probability be referred for mediation, court-connected mediation very early during the proceedings, because in many of these instances, when the matter goes to mediation, the matter is then settled and the defense is withdrawn. However, if the matter is not settled during the mediation process, then it will go through case management, it will go through the pre-trial proceedings, and then there are certain affidavits that need to be filed in terms of Rule 89 that would not be normally filed in terms of ordinary action. Okay. Yeah, when you are on ADR, you're very far from RCR. Okay. Remember, when the matter is defended, a notice to defend is filed, then the file is docket allocated to a judge. That judge will then issue a case plan. In 90% of the time, the legal practitioners will then ask during the course of the case plan, the joint case plan that they file in terms of Rule 23, that the matter be referred to court-connected mediation at that point already. Now, you can approach this either by, at that point, allowing the parties to go for mediation, or insist that the parties first exchange pleadings and then go on mediation. So it depends on how you, as the managing judge, want to approach the matter. But there is reasonable success with court-connected mediation. So it is then, during the course of the case plan, the matter can be referred to mediation. In many instances, it will then be settled there. Once it's settled, the parties will draw up a settlement agreement. The defendant will withdraw the defense. Then the matter can proceed unopposed to court. And then we're at the point where the plaintiff will come and testify, place everything on record. Settlement agreement is handed into court, and then a RCR order is granted at that point. But if the parties doesn't settle at that point, it will proceed to Rule 25. Then we will deal with a the case management conference, where it is clearly indicated whether expert will be called, how long the trial will take. You know, there's that list that the court will then consider. And once the case management conference is then made an order of court, the matter will go to pre-trial. In pre-trial, as you know by now, then the issues that will have to be resolved, in fact, in law is set out, the issues that are common cause is set out, your list of witnesses is set out, whether there will be any expert witnesses called, etc. So then there is not a question of RCR, because it proceeds as a trial as opposed. So the court will then hear evidence, and then after having heard evidence, then make the ruling. So RCR at this, if it's opposed, is not on the cards. Ms. Clausen, when certain issues are opposed with the ancillary, it will then be referred to a managing judge. You get even on the in case management that the parties can settle certain of the issues, and that the matter is the divorce is then granted, but then the ancillary issues is further case managed up to a hearing. No, we don't, but there is social workers from the Ministry of Gender Equality and Child Welfare. Then there's also your private social workers, and there's also social workers at the offices of the Ombudsman available to assist. When the issue of experts is considered when it comes to minors, then the court can request that there's a joint expert report, because in many of these instances, each of the parties will have their own expert, but that a joint or expert report is then drafted to indicate on which issues the parties agree and which they don't agree. And then, yeah, the matter will proceed on that. It's, it's something like this can be very protracted. So that is why the rules also indicates that all the legal practitioners need to also work towards the objective of the court rules, to try and avoid undue delays and the waste of money, and to place everybody on equal footing. And that is why it's these matters, especially if it's defendant, it must be judge driven, so that the judge can be in control and see that the parties do not unnecessarily waste time in these matters. Thank you.